Some of you might have heard a little noise going on behind me. The little noise is called Kit, and he's 3 months old. And Kit is beautiful, articulate, and vocal. But Kit, too, is a victim of child abduction, because Kit will never meet his half-brothers and sisters. So what we have talked about today can affect the oldest and the very youngest, and that is why it is so important.
Order, order. Rachel Gilmour to move the motion.
I beg to move that this House considers the subject of international parental child abduction, and it's a privilege to make my remarks under your very capable stewardship, Dr. Murison. I understand that these issues are very sensitive and of huge human significance, and so I feel privileged to be able to bring the eyes and ears of the House to them. And I salute the left-behind parents, some of whom join us in the gallery this afternoon, for their indefatigability and for their courage. And I know that they will take little comfort in such words, but I must say it anyway, Chair. I think it important to emphasise the need not to prejudice ongoing legal proceedings, but as representatives of our constituents, we feel a natural and proper inclination to advocate for them. According to Reunite International, over 500 children are abducted from the UK by a parent every year. Among the families who attended the most recent roundtable on this subject here in Parliament, there were upwards of half a century of lost years. That is to say, lost contact with their children. The testimonies I have heard, though individually unique, paint a troubling, consistent picture. Deliberate misleading, ill-fated recovery attempts, and financial costs running into the millions. Many have travelled time after time after time to foreign jurisdictions in the hope of recovering their children. The human toll is staggering on both sides. The Hague Convention on the Civil Aspects of International Child Abduction provides the principal international framework governing these cases. Crucially, it mandates expeditious handling of abduction proceedings. Yet from testimonies I've received, months often elapse before the first substantive hearing, in a clear breach of the Convention. Such delays risk the factual entrenchment of the abducted child in the new jurisdiction, entirely undermining the notional remedy of return. The Convention exists precisely to prevent this outcome. Far too often it does not. There are several structural concerns that recur across the cases brought to me. First, the undermining of established jurisdictional findings. In one instance I learnt of, the High Court here had already determined the child's habitual residence to be in England, and the Polish First Instance Court was aligned, ordering return. However, the appellate outcome reversed this position, despite no dispute as to the original wrongful removal and no clear finding that the Article 13 threshold had clearly been met at first instance. This raises concern about consistency in applying Hague principles at an appellate level and the degree to which appellate courts revisit or expand factual assessments beyond convention limits. The second concern is the creeping expansion of Article 13b welfare arguments as a basis for refusing return. These provisions were always intended to be a narrow exceptions, not an open door for wide-ranging allegations. Where such arguments are routinely entertained without proper substantiation, there is a considerable possibility that summary return proceedings are converted into de facto welfare determinations, which is not what the Convention intended. Thirdly is the insufficient use of protective measures. In this case, the UK had jurisdiction and capacity to implement protective measures upon return, with an active High Court framework available. These mechanisms should be taken seriously and fully operationalised. Failure to do so risks turning theoretical concerns to harden into grounds of non-return. The post-decision consequences of such outcomes are stark. The child remains outside the jurisdiction of the habitual residence. There is no effective restoration of the pre-removal status quo, and contact arrangements remain limited and unresolved. This illustrates how delay combined with appellate intervention can effectively neutralise the Convention remedy entirely. I am, of course, conscious that not every parent who crosses a border with a child is a wrongful abductor in the conventional sense. There are genuine cases, and we must be clear-eyed about this, where a parent flees with a child from real, documented domestic abuse, and the law must be sensitive to that reality. Article 13b exists precisely for such circumstances, and where the threshold is genuinely met, it should, of course, be engaged. The concern is not with the protection itself, but with its expansion and, at times, its misapplication. The difficulty is that the very features which make these cases so emotionally charged also render them susceptible to the weaponisation of abuse allegations as a litigation strategy. It is therefore incumbent upon courts and authorities to apply rigorous scrutiny to such claims, neither dismissing them reflexively nor accepting them uncritically, so that the protection is reserved for those who genuinely need it, rather than becoming the means by which the Convention's core remedy is routinely frustrated. The Child Abduction Act 1984 does not provide for the occurrence of a criminal offence when a parent has consent to take a child out of the country, but then fails to return them. This legal loophole became known as the Nicolau problem, following a 2012 judicial review process. The Law Commission's 2014 report identified this legal blind spot and recommended a change in the law. And I'm pleased to say, Minister, that the Crime and Policing Bill, which completed its passage through Parliament late last night, will finally close that loophole. All abductions in the UK will now be criminal. Based purely on the volume of human stories, Poland appears to be at the sharp end of these affairs, and I must set out the record plainly as it stands. The European Commission launched infringement proceedings against Warsaw, and the European Court of Justice concluded that steps taken by the Poles to disrupt and ignore Hague Convention orders were in contravention of EU law. A financial penalty was imposed for such intransigence, and I would very much welcome the Minister's reflection on the status of the British Government's support for the European Commission's proceedings in relation to Poland's infringements in this area. The European Court of Human Rights found that while initial steps were timely, subsequent enforcement actions were marred by delays, ineffective procedures and a lack of coordination. Moreover, the court determined that authorities repeatedly relied on flawed or misleading information and failed to adjust their strategy when previous steps failed. The failures were primarily attributable to the authorities and not solely the abductors' actions. It therefore held that there had been a violation of Article 8 of the Convention. The bottom line is this. Abductions to Poland often endure because of the incompetence, deliberate or otherwise, of the authorities. At the very least, the conduct of the Polish authorities has been marked by willful negligence, if not a sinister, concerted effort to frustrate enforcement orders. This speaks to practices that seemingly have been institutionalised. And, Chair, listening to some of these stories, it is hard to shake the distinct impression of conspiracy, that the abducting parent is in coordination with the authorities, aided and abetted to evade enforcement. Britain and Poland have a close bond. I think of the brave Polish pilots who fought with British wings with distinction in our country's finest hour. In recent decades, many of Poland's sons and daughters have made their home on these shores. They say that friends should be able to talk candidly, openly and earnestly with each other, even when it comes to uncomfortable discussions. In fact, especially when it comes to tricky home truths. The government line is that these issues are raised at every opportunity with Polish counterparts. I appreciate that this is a delicate diplomatic dance, but Poland's famous intransigence on this issue has hardly been subtle. And so, beyond the diplomatic niceties, I would like to know what the response is when the question is put pointedly to Polish officials, because it should not be the case that when sincere representations are made at the highest level, they are met with prevarication. I now turn my attention to REMO, otherwise known as Reciprocal Enforcements of Maintenance Orders. Because there is much angst that the current default position is to enforce them without any scrutiny at all. In practice, this can result in maintenance being enforced against a left-behind parent, even in cases where there has been an abduction and an existing Hague return order. REMO cases are typically held abroad without the involvement of the other parent and with no opportunity for defence. Amounts are often arbitrarily assigned with no consideration of affordability. To the best of my knowledge, REMO enforcement has been successfully challenged on only one occasion, and even then, only on a technicality. But for left-behind parents, it adds insult to profound injury, expected to help fund the illegal abduction of their own children and often forced to spend thousands of pounds pursuing appeals in UK courts against REMO enforcement. This mechanism is problematic for clear reasons. Hague Convention return orders are effectively disregarded in financial enforcement proceedings. Left-behind parents may be required to pay backdated and ongoing maintenance. Worse still, this system risks inadvertently incentivising abduction because it can perversely result in delivering financial reward to the abducting parent. Surely, any case where there is a Hague Convention return order should not qualify for maintenance payments of this kind, and that is something that should be enshrined in law here. So I ask the Minister to help us understand what measures the Government can take to ensure adequate protection of abduction victims from being penalised in this way when foreign courts reward abductors with high maintenance orders in unreasonable circumstances. There's also an understandable concern that Britain's position outside the European Union may be influencing how such cases are handled in EU jurisdictions. There is a prevailing sense that the UK has been left out in the cold, perhaps even punished, and that other states have used the Brexit farrago as a smokescreen to turn a blind eye. While the precise impact is unclear, it is a mood worth acknowledging as part of the broader context, and I wonder whether the Minister may reflect on this point. I am told that the European Commission has a team actively working on these cases. Would there be an argument for a dedicated task force within the Foreign Office? I absolutely understand the pressures our Foreign Service finds itself under in these times of geopolitical turmoil, but I would welcome the Minister's view. Much has been said of the fragility of international law recently. It is for countries with shared values who believe in the primacy of the rule of law and international treaties to make this case by practising it. I would remind Warsaw, for instance, that Poland was a signatory to the Hague Convention too. In concluding, as I bring my remarks to an end, I would ask the Minister to outline what support children and families can access who have been the victims of abductions. Can the Minister furnish us with the statistics on repatriation, specifically from Poland? And if the Minister does not have these figures to hand, will he commit to providing such information in writing to me? I also ask, perhaps naively, whether in these often highly fraught cases sufficient consideration is given to the child's perspective. The child's voice is a good place to start and to return to throughout. Our role here is not to litigate constituent cases from the Chamber, but to push the Government to ensure that our counterparts honour the decision of our courts, to call on them to fulfil their obligations under international law and oversee the safe and timely return of abducted children back to the country from whence they were taken. I implore the Government to bring all the diplomatic power we have to bear on this matter, because British children, wherever they are sent to or taken to, deserve nothing less. Thank you.